All right, so in part two of your video lecture this week, we're going to focus in on two specific areas of constitutional law that state actors need to be aware of. The first of which is due process. So you can see here, if we go to the root of the source here, we're looking at both the 15th Amendment and the 14th Amendment for due process. So the origination of due process comes from that Fifth Amendment, which essentially said no person can be deprived of life, liberty, or property without due process of law. And really, all the 14th Amendment did was extend that same coverage to states. So, really, the heart of this is the Fifth Amendment, which ultimately said that state actors have to follow proper rules and procedures before infringing upon someone's rights. Okay? So that's ultimately what we're talking about when we talk about due process of law. Now, there are a couple of different types of due process that we're going to identify here, and then we'll cover the various elements. Okay, so the first type of due process that we need to be aware of is what's known as substantive due process. So when we look at substantive due process, we're looking at the actual rules or policies or regulations that are in place and also how they're applied. Okay, so basically, if a sport or rec organization has a particular policy in place, they have to make sure that they're fairly applying that policy to all their employees. For instance, let's say that a park district has a policy about arriving to work at a certain time. And having this policy is fine, makes sense. It seems like something they could do. The problem would come in if they are actually applying that rule in an unfair way, right? So one employee is regularly showing up late to work and is not punished for that, but then one day another employee comes in late to work and is either fired or punished for that. So the idea of substantive due process is just making sure the policies you have in place make sense, and also that in application that they're being applied fairly, right? That's essentially what we're talking about here with substantive due process. Procedural due process is the other type of due process that exists within the Fifth Amendment. And the idea here is that if a state actor is going to infringe upon someone's life, liberty, or property rights, then they owe, a minimum level of due process before they do that, right? So before you're going to fire someone from a job, before you're going to remove a participant or a student athlete from a program, there are certain steps that need to be taken in order to provide that due process of law. So you can see here that there are essentially some basic things we can do as state actors. So giving someone a statement of exactly what they did wrong, right? That would be just bare minimum, something we could do. If we've enforced some kind of punishment, say we've kicked a participant out of a program for 3 weeks, we could provide them a written letter that explains what is actually being done. And then also just giving the person who is having their life, liberty, or property interests impacted the opportunity to comment, right? Essentially getting the chance to tell their side of the story, right? Those are things that the court would deem to be minimum due process, minimum what you would do if you were actually going to be taking steps that involve firing someone or removing them from a program. Now you can see that there's also other layers here. There are other types of due process that can be provided. And the truth is, maximum due process. So all of these things involving kind of what we mentioned over here, but also, the opportunity to have a hearing, the opportunity to appeal. These are things that essentially, if you have a deprivation that is greater, the more due process you want to provide, right? So if a court is looking to give someone the death penalty, for instance, they would want to provide maximum due process, right? Because you're talking about the greatest deprivation of all, right? Potentially taking someone's life. So in cases like that, you would certainly want to provide every potential type of due process just to make sure that things are done correctly. In a lot of the instances that we might be dealing with in K&R, probably more likely looking at kind of the minimum due process end of the spectrum. But certainly there need to be certain processes provided before we take someone's life, liberty, or property rights away. Okay. So in order to actually prove a due process claim, there are 3 elements that the court will examine. And similar to our lesson on negligence, we're looking at a burden of proof being on the plaintiff. Okay, so plaintiff who's filing the due process claim, they feel like their due process rights have been infringed upon. They have to prove these 3 elements in order to be successful. So this first element is that they have to prove the action in question was a government action and not a private action. This goes back to that concept we introduced in the first video, right? This concept of state action. We learned through that first video and the reading that one cannot sue an organization under the Constitution unless they are a state actor, right? Unless they're acting on behalf of a government entity. So it makes sense then that in order to prove a due process claim, you first have to be able to prove state action, right? You have to be able to prove that the organization or individual that you are suing is in fact a state actor. And if you can prove that, then you can move on to these other relevant elements. If you cannot prove that they are state action, then there is no lawsuit under the Constitution. There may be other avenues to pursue a lawsuit, but not one under constitutional law. Okay, element 2, the plaintiff has to be able to prove that the action affected them personally, right? Another way of saying this is basically they have to be able to show that their due process rights have somehow been violated, right? And they do that by either showing that their procedural due process rights or their substantive due process rights have been infringed upon. So we've already covered those. So we know that basically the plaintiff just either has to show that they were not given proper procedures in their case, or they have to be able to point to the actual policy or the implementation of that policy and show that there was an issue of fairness, right, in terms of how that was applied. So in order to prove element 2, you do not have to show both procedural and substantive rights have been infringed. Just one of the 2 has to be present in order for there to be a successful proving of element 2. Finally here, if you're the plaintiff, you have to be able to show that there were life, liberty, or property interests at stake. So what does that mean exactly? Well, in order for there to be an infringement of due process, we know based on our definition here of due process that it says it right in the terminology, right? No person shall be deprived life, liberty, or property without due process of law. So it would make sense then, in order for you to successfully pursue a due process claim, that at least one of these things has been impacted if you're the plaintiff, right? Now, the good thing about what we do in K&R is that very rarely, if ever, will there be an instance where we as state actors working for a K&R organization are taking someone's life, right? That is something that criminal court system in this country does, but really not something that K&R practitioners should ever be involved in, right? So really all we're looking at are liberty and property interests. Now, liberty interests are essentially, someone's freedom to pursue their interests, to pursue their dreams, right? This idea of liberty is very central to the U.S. Constitution. So if, for instance, someone does lose their job or loses a scholarship, for instance, or, participation rights as part of a sports club or team, they could argue that their liberty rights have been impacted, right? Because they've now lost out on that opportunity or the opportunities that were inherent in that. You could also argue that if someone's to lose a job, potentially that could harm their ability to pursue another career or another line of work, right? Because there could potentially be harm to their reputation. So that might also fall under liberty rights. This other one that's common in our field is property interests, right? So this one's pretty straightforward. If you fire someone and they lose their job, they not only lose their paycheck, right? They lose sort of this guarantee of having a sustained employment contract, right? So that would be an example of someone losing their property interests. Now, our courts have also said in past cases that scholarships, so a college scholarship that a university hands out to athletes, is also considered or classified as a property interest. So that's why you have some cases historically where student athletes have lost their scholarship and then pursued a due process case against the university, arguing that their property interests have in fact been impacted. So again, all you have to do if you're the plaintiff here is show that just one of these interests have been impacted by the defendant's actions, right? And again, in our field, very rarely, again, if ever, would you see life interests at stake, right? Because when we talk about life, we're talking about taking away someone's life. And while certainly that's relevant if you are, being accused of a heinous crime and you're on court or you're in court and potentially going to get the death penalty, that's just not something we're dealing with. So whenever you see a due process case in this class, make sure you're focusing on the liberty and property interest, because those are far more likely to be on the table in a K&R case. All right. Speaking of, I've shared an example with you on Regina that I think is a really interesting case from a few years ago involving due process in our field. And this case, you might have seen in the news at the time, involved this soccer player for UConn. She was playing on the team when they were playing in a championship game, which was airing on one of the ESPN networks. Their team won, and in her excitement at the end of the game, she gave the middle finger to the TV camera, which obviously then, produced and sent that over the airways. So a lot of people saw it. Essentially, what ended up happening with her is the university pulled her scholarship and essentially kicked her off the soccer team. Claiming that she went against their policies in the student athlete handbook, right? But ultimately, she pursued this case under due process, claiming that she wasn't given proper opportunity to kind of tell her side of the story, to appeal this decision. Basically, the school let her know in a phone call that she wouldn't be returning. So she claimed that both her procedural due process rights were impacted through that, and she also claimed her substantive due process rights were infringed upon because she argued that there had been other student athletes at the university who had potentially done worse things outside of their sport, and they did not get a similar punishment as her, right? They got a much more mild punishment. So she also argued her substantive due process rights were at stake. And ultimately, that both her liberty and property interests were impacted, right? Because she both lost her opportunity to pursue the sport that she loved, and she lost out on her scholarship with property interests. So I would really encourage you to read through that article on ReggieNet, because I think it does a good job of breaking down a fairly clear-cut example where a state actor did not really provide proper due process when taking away someone's life, liberty, or property interests. And ultimately, I think this lawsuit could have been avoided had they simply taken some of those steps that we discussed earlier. Okay, I'm going to transition now to looking at another area of constitutional law, which is the right to privacy. Now, we've already talked a little bit about right to privacy this semester when we talked about intentional torts. But we're going to shift gears a little bit here and focus on right to privacy in a very specific area in our field, and it's this concept of drug testing that is fairly common in this country, especially in K through 12 school systems, and more specifically when we're talking about student athletes. So just really quickly, when we think about where this right to privacy comes from a constitutional perspective, we can see that if we look to the Fourth Amendment, it pretty clearly states that this is a protection for U.S. citizens, right? I just pulled a little excerpt here didn't pull the full verbiage, but essentially says that the right of the people is to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, right? So basically just guarantees that American citizens are protected against arbitrary invasions by government officials, right? That in order for the government or a state actor to invade your privacy, they have to have a valid reason for doing so, is essentially the heart of the Fourth Amendment here. So as I mentioned, probably the most common application for the Fourth Amendment in sport and rec is this concept of drug testing, at least in recent years. Certainly there are potentially some other privacy issues that we could get into on the sport side of things, but really want to focus in on this idea of drug testing because I think it's one that's interesting and has evolved here over the last 2 decades. So basically what we know from prior court decisions is that courts have determined that drug testing does in fact fall under the Fourth Amendment. Now keep in mind, when the Constitution was written, there was no drug testing, right? The idea of drug testing was not a thing, so it's not as if it's actually written in the Constitution. But as we know, court precedent or prior court decisions can impact the way that we understand and apply laws under the Constitution. So that's what has happened here with the Fourth Amendment, that prior courts have looked at this issue of drug testing and in fact said that even though this doesn't look like a typical example of search and seizure, that in fact, asking someone for their bodily fluids in order to test them is in fact a version of search and seizure, right? So they have classified these as Fourth Amendment cases. Now, what does this mean for us in rec and sport? Well, basically what it means is that in order for state actors to drug test, they have to have a reason for it, right? They have to have a legitimate reason, something they can justify in order to do so. Because again, with constitutional law, we're looking at this balancing act where courts are essentially weighing sort of the state actors' interest in furthering whatever their governmental function is. And then on the other hand, they're trying to weigh individuals' rights and their personal freedoms, in this case, this idea of privacy protection. So the courts have to weigh these two things, and ultimately what they're looking to from a sport or rec organization is that they can justify having these policies in place. Okay, so I mentioned there have been some court decisions here within the last few decades that have really created what is currently kind of our known understanding of drug testing and what state actors can and cannot do in this country. So just to give you a very brief history lesson here, if we look back to the early 90s, basically the courts did not view drug testing as something that state actors should get to do if it's done randomly. So you can see in this University of Colorado versus Dearden case, they found that random, suspicionless urine testing was in fact a violation of Fourth Amendment rights. So basically they said, as a state actor, doing this random drug testing in a school setting would be a violation of privacy. And as you can see, if you look at these other two cases, one that came in 95 and one that came more recently in 2002, the courts have really shifted their perspective on this, meaning that they've moved away from sort of being in the corner of the student athlete to being more on the side of the state actor who is trying to implement drug testing. So you can see in 95, this is a pretty major Supreme Court decision that set a massive precedent where they shifted gears and said actually drug testing can be permissible because the government interest here is higher or it outweighs the student athlete's privacy interests. So ultimately, in this Verona case, the schools argued that they had legitimate reasons for drug testing, right? Whether it was safety and concern for the student athletes wanting to keep their interscholastic sports clean, that was, I think, a major argument for them. And ultimately, the court said, yeah, that outweighs these individual students' privacy rights. So they allowed it to go on, which again was sort of cemented in 2002 with this Board of Education Independent School District case, where not only did the Supreme Court confirm that random drug testing was okay and still constitutional, but they also expanded it to include other groups of students, so other extracurricular activities, as you can see, that are listed there. So as I mentioned, we see this interesting shift from the early 90s to the early 2000s, where the courts have essentially decided, school districts have the ability to randomly drug test. It does not, in fact, a unconstitutional practice, as long as they can, again, show that they have some kind of governmental interest in doing so. I am sharing in ReadyNet a really good New York Times piece on this whole concept of drug testing in schools, and it really focuses in on that last case, that Board of Education case. And you'll see that the date here is a little bit old, 2002, but that's when that court decision came down, and really there hasn't been much movement on that since that Supreme Court decision. So I would take a few minutes to read that article. It's a really thoughtful piece about the court's decision and kind of how this impacts sport and rec moving forward. Okay, so just a really quick wrap up here, and then I'll let you go. The big things for this week is really establishing what constitutional law is, and more specifically establishing what this concept of state action is. So if you're still a little bit confused about what state action means or who is actually classified as a state actor, make sure you stay tuned to the video debrief on this week's case study. I think that might help clarify things, or jump in on office hours, because that really is an important concept for us to understand, not just for the content that we're looking at this week, but next week as well. And then make sure that, in terms of the content for this week, that you have a good grasp of that concept of due process, and that you can apply those elements to a scenario. You'll see that in your action items for this week, you're going to have a due process case, actually 2 mini cases to look at, where you're going to have to apply those elements. So hopefully that'll be good practice for that. Just a quick preview for our unit next week. We're going to look at part 2 of this constitutional law unit, and we're going to get into more specifics on the Equal Protection Clause, which is part of the 14th Amendment and deals with this issue of discrimination. And then we're also going to break down the First Amendment and the various freedoms that are included or inherent as part of that amendment. It's always really interesting topical stuff to dig into there. So that's all I have for this week. Enjoy your week.